I commend this bill to the House.
The question is that the motion be agreed to. Charles Cheval.
Mr Speaker, as we've just heard from the Minister, this legislation would extend for 1 year only from 1 July the application of the Prisoners and Victims Claims Act 2005. And the thought is, as I understand it, that the temporary legislation that we're considering now is needed because the Act, the substantive Act, expires according to an inbuilt sunset clause that takes effect in 10 days' time. I think it's important to understand the context here, and in particular to revisit the history of the enactment of the substantive legislation so that we are fully cognisant of what we're doing in respect of this transitional legislation. Between 1998 and 2004, the Department of Corrections operated a punitive regime that was known as the Behaviour Modification Regime, later the Behaviour Management Regime, for short BMR. Now, that regime was heavily criticised in a High Court case, Taunua and the Queen, where Taunua complained about the operation of the BMR and gained a significant award of damages against the Crown because of the fact that the BMR was operated in such a way as to constitute an assault and a deprivation of the inmates' human rights. And as a result, significant damages were awarded in that case to the inmate. There were concerns at the time, given the high level of the award, that there would be substantial damages flowing against the Crown to inmates, but that the victims of the offending of those inmates, in order to try to get some sort of compensation for the wrong that they had suffered, would have to go through an expensive court process in order to make themselves whole. And yet the inmates concerned, against whom sentences had been entered because of the suffering that these victims had been through, would effectively end up with windfall payments that would not be able to easily be touched by their victims. So that's the context of the substantive legislation. That's why the Minister of Justice at the time, the Honourable Phil Goff, responded to those concerns by proposing the Substantive Act. And the intention, as can be seen from its wording, was that it would always be temporary, that there would be a sunset clause built into the legislation. It would apply only until 1 July this year. The present government, and the Minister was almost good enough to concede this, hasn't managed its order paper well. And so, as a result of that mismanagement, and I don't know whether that's her responsibility or the responsibility of her predecessor, Mr Power, but for whatever reason, the replacement legislation hasn't come to the House in time to be reenacted to avoid the operation of the sunset clause. There is a replacement act on the order paper, but I think the government realised that it wouldn't be able to get that legislation through all its stages, including the select committee hearing that would no doubt be appropriate for renewing the legislation, in time to be able to get it through before the sunset clause was triggered. And that is the only reason that we have the temporary bill now before the House. Now, I think it's important to say that there are some real concerns about the substantive legislation that is proposed to effectively make the Prisoners and Victims Claims Act permanent. And this was pointed out to us by a number of submitters in the committee. We heard from the Minister that of the 5 submitters, I think only one was vaguely supportive, and every other submitter was against this legislation. And they were against it because of the provisions of the proposed replacement. There are at least 2 reasons why the replacement legislation is bad law on its face. First of all, the Tonoa decision, which I mentioned earlier, has been to the Supreme Court. The Supreme Court radically scaled back the award of damages that had been given in the High Court. And so all that fear about inmates getting enormous amounts of damages from the Crown was really groundless, because the Supreme Court, our highest legal authority, has said actually the quantum that they can expect to receive from the Crown is quite low. And I note that the Minister recited some figures about damages that have actually been recovered under the regime. I think in respect of 25 claims processed to date, the actual level of monetary compensation that's been paid to victims is very low. I think she said $43,000. And that's proof, I think, of the concern here. A special regime set in place because of concerns that are no longer live, resulting in actually quite low payments to victims of crime. The second problem with the substantive regime, sir, is that the legislation, as I've said, was always intended to be temporary. It was always intended to address the fact that corrections had wrongly put in place the BMR. The BMR, the Behaviour Management or Modification Regime, was done away with. And corrections, as I know a number of members who have visited prisons or taken an interest in the issue will know, has taken a number of important steps to try to professionalise the operation of the prisons and to ensure that the sort of practices that we saw put in place in the 90s with the BMR cannot happen again on a systemic basis. So, the original case has been overridden substantially. The behaviour modification regime is no longer in place. The question therefore arises, why do we need ongoing legislation? And there's another issue, sir. It relates to the point that I made earlier about the figures that the Minister saw fit to release in her speech. Now, my colleague Leanne Dalzell at the Select Committee, when we considered this legislation, was very concerned about the scant nature of the regulatory impact statement that justified both this temporary law and the substantive replacement law. She wanted to know what the justification in monetary terms was for reenacting the regime. And the Minister's officials told us very clearly at Select Committee, no, that information is not available, the Minister does not want you to have it, it's sensitive. Well, unfortunately we don't have a terribly good example of joined-up government at the moment, because all those figures were released by the Department of Corrections yesterday in the estimates process, and they do make very interesting reading. See, there are only currently 19 claims against the department awaiting adjudication in respect of the prison service, although one is a class action, and 3 against probation services. As far as officials can tell, there might be another 20 cases out there, but that's simply an attempt to quantify contingent liabilities. So a real question has to arise as to whether a problem that has given rise to only 22 actual and 20 potential cases since 1995 merits a statutory regime. Judith Collins has given me a commitment to negotiate over the content of the replacement legislation during the year for which this Act will be extended if the House passes this bill. Frankly, sir, I and my colleagues need to be convinced of the ongoing need for it, or of any special legislation to apply in this area. If there is to be special legislation, there are some major questions that have to be asked. Why should the legislation apply only to inmates? Why shouldn't it apply to all those who are convicted of an offence, perhaps including a community sentence? Why couldn't the judge give an indication as to sentencing that would include any compensation that should be payable to victims in the event that the person subject to a sentence came into a windfall? And why should the windfall be limited to a payment from the Crown? Why shouldn't it include a testamentary benefit, a lotto win, any other sort of recovery of funds that was unexpected? So, sir, I accept, and my colleagues accept, that it is proper to preserve the status quo for a year and to allow those discussions about a replacement. And for that reason, sir, and that reason only, Labor will support this temporary bill. Mr. Speaker.
I call Tim McIndoe.
This is a bill of very limited application.